and welcome. My name is Malcolm Neekirk. It's Monday, the 9th of March 2026, and this is number 62 in our coffee break briefings. Today's theme is the National Security and Investment Act 2021. Brief overview of the legislation here is it gives the government the right to scrutinise business transfers if they perceive a risk to national security. The Secretary of State can intervene, they can impose conditions, restrictions, or they can even block a proposed sale. There are two policy objectives that are intended to be balanced by this legislation. One is the need to keep the UK open to inward investment, and the second one is the protection of UK citizens and the UK's strategic interests. There are two circumstances when you might encounter the National Security and Investment Act in practice. They are when you're dealing with business or asset sales, or if you're dealing with restructuring work. And in business sales, the legislation can be triggered if there is a national security risk. In restructuring, it's not so obvious, but if there is a national security risk, you could find the legislation triggered if there is a control to the change of the company that's being restructured. And this could happen through, for example, debt for equity swaps. And there are three things that you need to be aware of in terms of when the legislation applies. And these are mandatory notifications, voluntary notifications, and the government's call-in power. The mandatory notification are the situations where your buyer has an obligation to tell the Secretary of State that they are buying the business. Voluntary notification is where there is no obligation to do so, but your buyer decides to do so in any event. And this would be a precautionary notification to the government. There are many shades of grey in this legislation. It's not always going to be clear-cut whether the proposed transaction is under a mandatory notification or not. And so if you're not sure, then it's possible to make a voluntary notification to seek clearance for the transaction in any event. And one of the reasons for making a voluntary notification is to avoid the government's call-in power. The government has got the ability to scrutinise a proposed business sale or even a completed business sale, even if it's not been formally notified to them by the buyer. And having called in the transaction for review, the government would then have the right to impose conditions or block it, or if the sale has already completed it, they could even unwind it, they could reverse the transaction. The consequences for you as an insolvency practitioner involved in a potential sale are firstly the risk of delay. If there is to be a notification of the transaction, then that is going to take longer before you can complete it. There's going to be additional cost in terms of additional professional fees and arising from the delay generally. There could also be implications for the price. If you've got competing bids and one of them has got a much greater risk of being called in and conditions imposed on it than the other, you might go for the less risky bid, even though perhaps the price is lower, in the interests of getting the transaction completed sooner. And then there are the risks of non-compliance, the consequences of non-compliance, which could be that the sale could be avoided, it could be set aside, and there are, of course, as you would expect, potential criminal and civil penalties for non-compliance. I've already mentioned the legislative objectives of being to protect national security, to protect UK citizens, and to keep the country open for inward investment. And I'd like to emphasise as well that there are no minimum sizes for the businesses that can be affected. It's not just for top-end sales. It can be, in theory at least, a sale of any size. All it takes is for the Secretary of State to suspect a national security risk associated with it. And as you would expect, as well as the primary legislation, there are also regulations. There are regulations that define the 17 sensitive sectors where there is the greatest risk of the government wanting to call in a business sale for review. There are regulations about financial penalties, regulations about delivering documents. There are regulations about the forms that you should use for mandatory notices, for voluntary notices, and for validation applications. And there are also regulations that carve out notifications and reviews that were already running under the previous legislation. So how new is all of this? The legislation's been in force for just over 4 years now, since the beginning of January 2022. The Secretary of State can look back over the past 5 years and call in for review transactions that happened up to 5 years ago. And this legislation replaces the regime that was previously in force under the Enterprise Act 2002. Let's look at some of the statistics from last year. Then there were just over 1,100 notifications made to the government, and about 5% of the notifications were called in for detailed review. There were also a similar number of acquisitions that took place without government approval, where the government should have been notified before they took place. There were 16 final orders made. These would have been orders either blocking a sale or imposing conditions on it. And there was one transaction that was ordered to be unwound. And that, I would guess, would be one of the transactions that should have been notified to the government, but was not. This is the steps that the buyer should follow in any acquisition. Firstly, they should check whether they are outside the rules. If they're buying a business where there is no national security implications, or if the change of control is one that is not going to trigger any ability for the government to call it in for review, they'll be outside the rules. There's nothing further that they need to do. If they're inside the rules, they then need to decide whether they should be notifying this transaction to the government, either as a mandatory notification or on a voluntary basis. If they feel that they should notify, then of course they have to do that. And then once they've notified the transaction, they have to wait for the government to review it. And on its review, the government has a choice of 3 things to do. They can either clear the transaction, or they can allow it to go ahead, but with conditions imposed, or they can block it, or if it's already completed, they can unwind it. There are 17 sensitive sectors which are defined in the regulations, and these should be on your business transfer checklist as the ones that you should review for the need to comply with the legislation. I'm not going to read all of them to you. They're on the handout that will be circulated after this. And in addition to these 17 that are already on the statutory list, there are another 3: semiconductors, critical minerals and water, that may be added. And probably the prudent approach at present is to assume that there is at least a potential for a risk to national security if you're dealing with a business in any of those sectors. Now, in terms of what is actually called in and what is actually reviewed by the government, just over 90% of last year's transactions fell within these 3 sectors: defence, military and dual use, and advanced materials. Those are very much the emphasis of the cases that are most likely to be scrutinised. And in terms of which countries' transactions are scrutinised, just under half were actually transactions with UK businesses. So although this is about the risk of overseas owners acquiring businesses. Nevertheless, the obligation to notify the government and for the government to review is not triggered by a change of control to an overseas buyer necessarily. The government has got the right and will review transactions which are purely domestic transactions. About a third of the transactions that were scrutinised were transactions where there was a Chinese aspect, and the rest were ones that involved the United States. You can ask the government for advance guidance on whether an acquisition is notifiable or not, and the email address for doing that is on that slide. But that's something you would be likely to do only in consultation with your legal advisors, and you have to remember that the advice that the government gives is not itself legal advice. They will emphasise that you will need independent legal advice yourself, and there's no point in asking the government a hypothetical question and expecting a useful reply from them. I'm now going to look at some of the jargon that is used, some of the terminology that is defined in the legislation. The first one of these is a trigger event, and a trigger event, as the name suggests, is what actually triggers the requirement to notify the transaction to the government. And a trigger event is a change of control, which I'll talk about in a few minutes' time, a change of control of either a qualifying entity or a qualifying asset. Qualifying entities are basically businesses, and qualifying assets are basically business assets. The acquirer is, as you would expect, the one who is taking control of the asset or the entity. And the qualifying entity is the owner of a business. It'll be something like a company, an LLP, or a partnership. It won't be a sole trader. The sole trader is not a qualifying entity for this legislation. Foreign companies can be regarded as qualifying entities, but only if their activities are in the UK or if their customers are in the UK. And a qualifying asset will be something like land, tangible movable assets, that is plant and equipment, or intellectual property rights. And in some cases, overseas assets can be qualifying assets. There are two definitions of what can be a notifiable transaction. One of these is, to my mind, quite an objective one. The other one is rather more subjective. And a notifiable transaction will be one that takes the acquirer's direct or indirect control through a particular threshold of control. And the thresholds here are set at over 25% control, over 50% control, or 75% control or higher. And a transaction that passes through one of those transactions will be a change of control that is potentially a notifiable transaction. The more subjective definition of notifiable transaction is one that gives the acquirer direct or indirect control, either through being in a position where they can block a resolution. And that might not be as a result of the number of shares that they hold, that might be as a result of an investment agreement or a shareholders agreement, something of that sort. Or if the acquirer has got direct or indirect control through licensing rights that it's got. So this might be licensing the IPR or some sort of licenses over the plant and machinery that's being used in the business. It's unlikely that a loan could be a trigger event. So in your restructuring cases, that's not something that you need to worry about too much, except that it is possible that investment agreements or debentures, through the influence that they give the financier, those could represent a change of control. So again, this is an area where in restructuring you might have a change of control that is a notifiable event. And what about if a qualifying floating charge holder appoints an administrator? Is that going to be a change of control? Well, no, it won't be, because there is a specific carve out for administrations. The appointment of an administrator, whether by a qualifying floating charge holder or by the company or its directors, that is not regarded as a change of control. But potentially, if you were to be appointed as a receiver, a fixed charge receiver of some of the assets, that might potentially be a change of control. And other situations would be, let's say that you're appointed as liquidator over a company which itself owns shares in a subsidiary. As liquidator, you would be regarded as having control over those shares, and so your appointment there would be a change of control, potentially, of the subsidiary company. And the same thing would apply for shares that are in a bankrupt estate. The vesting of those shares in the trustee on their appointment could be regarded as a change of control of that particular entity. Now, those are likely, or they may be exempted from the legislation in the future, which suggests that the government is perhaps not so greatly concerned about the sort of change of control that takes place on your appointment as an office holder. They're more concerned with the change of control where you're realizing the assets. Let's look at the timetable from the point at which your buyer notifies the Secretary of State. How long might it take for the transaction to be reviewed? Well, let's say day one, the buyer notifies the Secretary of State. You've then got 30 business days. The government's got 30 business days, during which time they must either clear the transaction or call it in for detailed scrutiny, or they can extend the time by a further 45 business days. So you're looking at potentially up to almost 3 months for this initial review period. And during that initial review period, the Secretary of State can ask the buyer to agree more time. And the buyer is quite likely to agree that extension of time, because there'd be the risk that otherwise the Secretary of State will make a quick decision on incomplete information. And it's perhaps less likely to go the buyer's way than if they continue to cooperate and provide more information, allow the government more time. The statistics show, however, that last year all cases notified to the government were either cleared or called in within that first 30 business day period. So you've got a good chance of getting clearance within 30 days if you're going to get clearance. The risk, of course, is if the government calls in the transaction for detailed scrutiny within those 30 days, because there are no time limits that then apply. All bets are off. It will take as long as it's going to take. But once you've got clearance, you're good to go, because the government can intervene then only if they were given information that was false or misleading. So again, if you've been working with the bidder, it's not in anybody's interest to mislead the government about this. You should be okay once you've got clearance. Now, can you accelerate a decision within that first 30-day period? Well, yes, you can. You've got the right to ask the government to expedite their decision on whether or not to call in a bid for scrutiny. Of course, the risk with doing that is that you might find that they're perhaps more likely to call it in for scrutiny because they may not feel that they can make a safe decision within an expedited period. And once they have called it in for review, it will take as long as it's going to take. You've got no right to ask for an expedited decision at that point. And of course, the very fact that the business is in financial distress may have a direct bearing on the national security risk. If you've got a business of strategic importance that is at risk of closing down, that's going to be a relevant factor. That should be disclosed to the government, but you can't just say, well, it's at risk of closing down because we're about to be appointed as administrators. You have to give what is effectively a full independent review with financial information attached to it, and also with information about support or lack of support from key stakeholders and creditors. And remember, of course, the the big risk in all of this is that the sale is potentially void if it was notifiable, and if you go ahead and complete it without approval from the Secretary of State in those circumstances. There are exceptional cases where the Secretary of State can call in cases that are not under mandatory review, under mandatory notification, and the government can even call in cases that are not in one of the 17 listed sensitive sectors. And the Secretary of State has this overriding ability to call in and review cases if they think that there is a national security threat because of who the buyer is, what the asset is, or what the particular trigger event is, what the nature of the sale or acquisition is that is being proposed. So in terms of the sale process itself, at what stage should the buyer notify the Secretary of State of the proposed transaction? And of course, it should be when the terms are firm enough that the Secretary of State can assess whether the legislation applies and whether there is a national security risk to the proposed transaction. And so this might be when heads of terms are agreed, it might be when financing is in place, it might be when the buyer's board is reviewing the purchase, or if it's a public bid, it may be on a public announcement of either a firm intention to bid or a possible offer. Let's look at how the buyer notifies the Secretary of State. As you would expect, it's done online, and as you would expect, there is a form. In fact, there are 3 forms, and you have to use the right one depending upon whether it's a mandatory notice, whether it's a validation application, or whether it's a voluntary notification. And that has to go to the Investment Security Unit at the Department of Business and Business Technology, is it? And the email is on the screen there and in the handouts. Possible government interventions: once they've received notification, they can issue an information notice, which is where they're asking the bidder to tell them more about the transaction. They can issue an attendance notice, which is saying you've got to come in and talk to us about it, explain what all of this is about. They can issue an interim order, which can stop either you, on behalf of the seller, or the buyer from doing something that the government thinks is unhelpful at this particular stage of the review of the transaction. And when they get to the end of it, if they don't want to clear the transaction, they can impose restrictions in a final order. And within the final order, there will be statements in there about how the buyer has to prove compliance with the conditions that are being imposed and what the consequences will be of failing to comply with those conditions. That now takes us to the summary slide. So these are the things that you need to watch out for. There's a possibility of the National Security and Investment Act being triggered if you are selling or restructuring a business. The key factor here is national security. So that's got to be uppermost on your checklist, is to think about whether there is any sort of national security implications around the business or the transaction or the buyer. There's no minimum size for the businesses affected, so you can't assume that just because it's a relatively small transaction, it's going to fly below the radar on this. There is a list of 17 sensitive sectors, which is likely to be increased to 20 sectors. Those should be on your checklist as a matter for review at the time of appointment as to whether there is a possibility of the legislation being triggered. It will be a considerable inconvenience to you if the legislation is triggered because of the additional time it will take for the transaction to be completed and because of the additional costs associated for it. But it's worse if it's triggered and ignored, with the risks there, including the risk of the transaction being set aside. You have to vet who the buyer is, because the identity of the buyer is itself a potential risk factor, and that might mean that you would be preferring one buyer over another if you've got contested bids to review. Most of the obligations for compliance with the legislation are on the buyer rather than on you as the seller, which is good, but you are going to have to cooperate with the buyer and collaborate with them in the information that they provide, and probably even their decision about whether they notify the government or not. So I don't think I've received any questions about the presentation, so I will move on from this slide, and I will give you some key dates for your diary. There's the R3 Southern Forum in London in just over a week's time. Still places available, but you will need to book within the next day or two if you want to take part in that. The date for the next coffee break briefing is Monday the 13th of April. I will provide information as to what the topic for that will be, and in addition to the SESCA Insolvency Seminars and Conference, there is the Frettons' 4th Annual Insolvency Conference on Friday the 5th of June. Please do make a note of that in your diary. We will be sending out booking information for that very soon. So thank you all very much indeed, and I will see you again, if not at a conference or in other working arrangements, at the next coffee break briefing. Thank you very much, and goodbye.